Thank you, everyone, for joining us for our 2025 employment webinar series. Today, we're talking about labor arbitration, maximizing your chances for success. I am Kara Maciel. I am founding partner of the labor and employment practice firm here at Maciel Carey. I represent unionized and non-unionized companies on a variety of issues that apply under the National Labor Relations Act, including first chairing collective bargaining negotiations. I've handled union elections. I've handled, dozens of arbitrations that we'll talk about today, as well as providing strategies for non-unionized workplaces on how to, maintain a positive labor workforce. In addition to my traditional labor background, I also advise employers in federal and state litigation on the myriad of employment-related issues, as well as counsel employers on handbook policies, other issues relating to employment and discipline, and a variety of internal investigations. I'm thrilled to be joined by my colleague, Mark Trapp.
Hello, everyone. Good morning. My name is Mark Trapp. I'm in the Chicago office of Maciel Carey. And I have a broad-based labor background as well. I've been practicing for 25 years, and I guess if I think about it, Kara, most all of it has been with you at various places, but for the last 8 years here with you at Maciel. I handle arbitrations, I handle collective bargaining, elections, all sorts of traditional labor stuff, and I deal with multi-employer pension plan withdrawal liability, which you'll be glad to hear is not a topic of conversation today. We'll be talking about arbitrations, and Kara and I have arbitrated cases together over the years, and we look forward to sharing some tips of the trade with you.
Great, thanks, Mark. So for the next hour, we're going to be covering these broad 4 sections of our webinar. First, I'm going to talk about contract administration and grievance handling, which is really the very first preliminary part before we ever get to an arbitration. Mark's going to cover various settlement opportunities and other preliminary considerations. I'm going to cover arbitrability issues, preparing witnesses, and securing evidence leading right up to the arbitration hearing. And then Mark will close out with tips and strategies for conducting the hearing and any post-arbitration briefing. So with that, let me kick it right off with contract administration and grievance handling. So the first thing you want to know, you got to know the rules of the road, and that is laid out in your collective bargaining agreement. Oftentimes, the CBA is negotiated every 3 years, maybe even every 5 years, as long as I've seen. And in between the times that it's negotiated, it's very rare that managers and supervisors that are responsible for implementation of that collective bargaining agreement read and reread and refamiliarize themselves with the collective bargaining agreement. So really, it's a good idea to make sure that your managers that are supervising unionized employees review that CBA maybe once, twice a year at least. Do some regular training on it so that they know that they are implementing these, the terms and conditions of the CBA properly, including payroll. I can't tell you time and time again that I'm in an arbitration, that I'm preparing, we're reviewing a CBA, and all of a sudden finance says, that's never how we've done it before. We've always paid them this way. And so it's just a good refresher on what you need to be doing to make sure that you're in line with the CBA and not inadvertently doing things that could lead to a grievance or arbitration. And that includes side letters, right? So you negotiate the collective bargaining agreement, but sometimes the union and the employer will negotiate a separate issue that they don't want memorialized in the terms of their CBA for a variety of issues. That's set forth in a side letter, and you want to make sure that everybody understands what's in those, and those are equally being implemented appropriately, because those are incorporated in the collective bargaining agreement and oftentimes can be considered an issue for arbitration. So really training, as I mentioned, training your managers and supervisors on contract compliance should be an annual, if not biannual event. Continue as part of your regular meetings. You want to make sure you're keeping accurate records and documentation, particularly as a respect to pay, any meal and breaks that you're providing, any additional overtime, things relating to compensation and benefits is very important to maintain. as well as documentation relating to discipline. If you get a disciplinary grievance, you want to make sure you've got all of the right documents that are leading to why that discipline was implemented that can be used to support your position in arbitration. And then making sure that when you are documenting that discipline, it's consistent. It's across the board. In the event that the union requests, hey, can I see all other disciplines for this same reason, you've got consistent documentation across the board that shows that this is how you've always handled this particular infraction, and it just justifies potentially a just cause for termination. Once you're becoming familiar with the contract, there may be a situation where either you as the employer or the union files a grievance. And so what is a grievance? Broad brush, it is a formal claim that's filed by the union or the employer that one party in some manner has violated the collective bargaining agreement. It is usually defined in the contract, and we highly recommend that it should be defined in your contract. So if you have a contract where what a grievance is not defined, that's something you might want to mark for your next round of contract negotiations. Is something to amend and modify. You might also see a provision in that grievance and how that's defined as what is not included as a grievance, things that are outside the scope of the grievance and arbitration procedure, which is something to review again with your CBA. With respect to the types of grievances, there's usually two, and that, as Mark will talk about, will really determine who goes forward with a burden of proof at arbitration. The first is contract interpretation. It's either the employer or the union has not filed some term of the contract, whether you're not paying overtime the way it should be paid out, you're not implementing a meal break provision appropriately, whatever it is, it's a term of the contract that doesn't impact employee discipline. The second kind is discipline, and that's really governed whether an employee was disciplined, and it's usually, suspended or termination, something that impacts their pay without just cause. And just cause is another provision in the collective bargaining agreement that should be well defined. If it's not, again, that's another red flag that you should tick off for your next rounds of negotiation. A lot of times you want to list what egregious types of behavior account for just cause, dishonesty, falsification of work records, even, harassment. Those kinds of egregious things automatically qualify as just cause, and it will help you be able to defend against any discipline for those types of reasons. Again, really, really good in this provision to spell these things out, not just say the word grievance in the CBA, not just say the word just cause, but have clear delineations of what that means and what the party's intent are, because that often is what is the subject of debate in an arbitration hearing. So what happens when one of the parties files a grievance, right? So you really want to make sure that you've got a detailed step in a grievance process. Oftentimes it can be 2 to 3, even 4 steps, right? So the first step can be bringing something informally by the employee to the employee's supervisor or to human resources informally about an issue that they're having. And that might be step 1, which is sort of a verbal or informal discussion. Step 2 is a written grievance. If this informal discussion didn't resolve the issue in a certain period of days, then either party can now file a written grievance. And it's really good idea to insist that the union file a detailed written grievance, right? So that it's reduced to writing, it's signed by the person who's filing the grievance, ideally by the union, and if it's on behalf of a particular employee, that employee signed the grievance as well, so they understand what the union is doing on their behalf. And with specificity as to what contract provision was actually violated, not just say Article 4, Section 2, specifically in what manner was the contract violated, who violated it, when was it violated. You really want to push back on the union to try and have as much clarity and detail in that, because It limits the union's ability later on to shift arguments. Oh, I wasn't talking about Article 4, I'm now talking about Article 7 when they're preparing for arbitration. So one of the things that Mark and I really try and get the union to do is detail as much as they can in this first step, providing a written grievance. And then there'll be second steps. If it, usually after a written grievance is set, within a certain number of days, you should schedule a grievance meeting with the relevant parties. So the union should be present, you should be present, another manager should be present, someone else who's involved in the details. And this grievance meeting is important because you, as the employer, the recipient of the grievance, you should be in listening mode. Hear, listen to what they're saying, ask good questions, really try and narrow down their facts and theories, particularly if the written grievance isn't as detailed as you ideally would want. This is a time to, again, really listen, not necessarily provide your response at that time. You want to be able to, answer questions if you can, but if they have questions, say, look, let me take those questions down. I can follow up with you in our written response. And then there should be, another step, or within a certain number of days, that the employer files a written response to the grievance meeting. And in that written response, you want to think through, what you might want to say there and how you want to articulate that, because it'll be the first time you have an opportunity to set your theories and response in place, and how much detail you may want to put there strategically may benefit you not to have as much detail as if later on down the road. So as I said, really the overall approach in the grievance process is for you to listen to why the union has filed its grievance and why it believes the CBA was violated, so that you can take enough information back and do what you may need to do to investigate the nature of the grievance. So in handling the grievances, you want to acknowledge and really understand the timelines of grievances in the calendar. This is what I mentioned earlier with respect to the steps. If your CBA does not already have detailed timing of each step in which each party has to respond, again, red flag, mark that for next round of negotiations, because if you don't follow the timelines properly, or if the union doesn't follow the timelines properly, it may give you an opportunity to argue that the union has waived arbitration. You still have an obligation to process the grievance, but the union may waive its right to arbitration if it does not follow the contract timelines. And that's something you want to be very mindful of from the very beginning of when the first written grievance is filed. And you want to make sure you are doing everything you need to do to respond within those timelines, so the union doesn't have an argument that the employer has violated and also cannot challenge a arbitrability question because they did not follow the timelines. So you want to look through, look through documents, look through issues of whether this particular grievance has merits. It's, the beginning of an internal investigation. This is the very first process. You want to be thinking very forward. What happens if this issue goes to arbitration? So you want to use your investigatory process with that mindset of litigation going forward. And that includes who you interview, what documents you collect, what statements you provide, because being mindful that most of the time, anything you're doing to investigate a grievance is not going to be considered confidential. And if the union wants to request that information through a request later on in arbitration, or as it continues to process its grievance, the board, the National Labor Relations Board, has largely held that that information should be shared with the union as part of its role in representing and advocating on behalf of its membership. So you want to be mindful about what you put in writing versus, what you don't. This is also a good time to be mindful that you want to put what we call litigators, a document preservation notice in place, right? You want to make sure that the people who have relevant evidence maintain that evidence and it doesn't get destroyed or inadvertently rolled over or inadvertently deleted through a document retention policy, so that videos, any photographs, any text messages, any really good things that can be used for evidence later on is maintained and kept so that it's not inadvertently deleted. And then you always want to use this time to think about, is this an issue that we want to resolve early? Is this something that we can meet with the union and with issue a settlement or some kind of resolution? Or is this an issue that could be larger operational impact to the organization, and it's something that you may want to consider fighting potentially through arbitration? So with that, I'm going to turn it over to Mark to talk about potential settlement opportunities.
Thank you, Kara. I liked Kara's thought about identifying the settlement opportunities, and to do that early. If it hasn't happened through the steps of the grievance process, it's something to consider once the grievance process is exhausted. I often say, that this generally applies more to litigation, but in general, and speaking broadly, often a fair or maybe even a bad settlement is sometimes better than good litigation, given the costs and the hurt feelings and everything like that. That may be even more applicable sometimes to arbitration, given that it's a labor relations issue and you often have to consider employee morale and costs under the collective bargaining agreement, the costs to push to arbitration and to pay for the arbitrators. So it's good to think about these things early on and determine what's best for the organization to fight or to look for some sort of hopefully successful resolution. Estimate your win and loss chances. Try to determine whether the probability of success outweighs the risks of trying the case, and what are the various benefits and burdens that would be associated with winning or losing. Most often you think of money, but in a lot of grievances, there may or may not be obvious monetary impacts on the result. You may have it's a scheduling issue, or it's an overtime issue, or something like that you probably could equate to money, and certainly does have a cost, but it's not obvious on its face depending on how it shakes out. Is it a significant or a recurring issue? And what is your worst case scenario? What is the absolute worst thing that could happen? Because that's a risk that should be taken into account. You should determine whether it's a popular employee, or is this the union steward that's pushing this issue? You need to understand the motivations behind the grievance itself, and that will make it easier to identify the interests of the person bringing it and potentially to resolve it. Sometimes the union just wants to see how far they can push you, and oftentimes there's turnover on either the employer side or on the union side. Maybe it's a new business agent or something, or a new steward, and they're feeling out the other side. So they start pushing a lot of things just to see if you're going to stand up for yourself or not. And sometimes there may be reason, even in a seemingly insignificant issue, to stand up for yourself and show that you're not going to be pushed around. Every time I think of that, I think of one example where I was representing an employer that had a small fee that was involved in the services that this employee provided. Very small fee. It came up relatively infrequently, and it was something like $50 that would be added to the pay for performing this task. It didn't happen all that frequently, and we were doing it right, but the union and this employee pushed it and kept pushing it, and this was as a broader assault on the employer through a lot of grievances, and we didn't back down, and we ended up going all the way to arbitration over this issue. And when we won, I think it sort of set the tone for the relationship thereafter, that they knew that we would stand up, and they knew that we would take even a seemingly insignificant issue to arbitration when it was obvious that they were doing it just to test us. Sometimes they'll see what they can get away with new employees, see how they're going to interpret the contract. So pay attention to turnover on one side or the other, and make sure that, as Kara already emphasized, that the new employees that are coming in are brought up to speed quickly on the contract so that the union cannot take advantage of them. Sometimes there may be just collective bargaining around the corner, and the union may be looking to rile up the troops, so they start filing grievances and whatnot. Pay attention to that as well. Let's go to the next slide. Oh, sorry, you do have to consider whether to disclose the facts. And through the steps that Kara was talking about, you may know something that the union doesn't, and you need to consider early on whether that's better to disclose to try to settle the case, or whether it's best to see what you can do as resolving the case before it gets to arbitration, and then keeping your powder dry until arbitration. That will vary issue to issue, but that's something to consider. At each stage, use the grievance process to your advantage. As Kara pointed out, at each step, you should be in listening mode and determining what is the union's story here and what is their interest that's driving it. Might you consider mediation? Some contracts have mediation as an option, and it's spelled out specifically in the contract. You may be able to use the FMCS, the Federal Mediation and Conciliation Services, who provide arbitration and mediation services that many of you are probably familiar with. Some of you may not know that the FMCS offers a free mediation service that parties can use in their labor relations. And that may be an option that you consider in certain circumstances. You can go there, it's confidential, it's free. You do invest the time and the effort, but in some situations, maybe a particularly sticky situation with a discharge or something, you may be able to utilize that third party to your advantage. There are also other paid options. You can use a neutral. You might even be able to use the arbitrator if the case is already set for arbitration. Oftentimes arbitrators will, right at the outset of the hearing or before with counsel, say, hey, has everybody really explored settlement here? And some are willing to act as mediator. It depends if you want to do that or not, and if they are willing to do it, and then whether, if it doesn't settle, whether you would want that arbitrator to consider or to continue with the arbitration. You may or may not want that. Also, it's important to note the confidentiality of settlement discussions. It's a pretty universal rule among arbitrators that they will not admit evidence of admissions made as part of settlement discussions or offers that you've made to settle. You may want to make that explicit if you're engaging in settlement discussions. So if you are looking at resolving a grievance, how might that happen? Well, the union could just withdraw it, and they do back down in certain instances and just withdraw the grievance and go on. Or they may forget about it. You may have the timelines, as Kara suggested, and it may just fall off. Sometimes an employee may have just wanted to, have their say, and the union files a grievance, and then it sort of fades into that good night. That's all fine and good. If it doesn't, though, and if it keeps getting pushed, then you might agree with the union. You might reach some sort of mid-range settlement where you agree that you're going to resolve this grievance on these terms. And if you are doing that, it's a good idea to put that in writing. And I've got some terms to consider if you do reach some sort of settlement. It's nice to have a written agreement. One thing that you can consider that Kara and I have used in the past to I think great effect is especially in a discipline and discharge grievance, a last chance agreement. A last chance agreement, you can spell out for an employee that, hey, this is your last chance. It is what it sounds like. And that's a potential advantage. Now, you may say, we've already terminated this person, or we've already disciplined them, and that's it, and that's all. But what if your documentation is not all that great? Or what if you find that there are some holes in the case that, even though you know what this person has done or how many times they've done it, the documentation may not be there, or there's a witness has left your employment and been and moved on, and they may not be available at an arbitration, or there's different considerations like that. You might consider a last chance agreement where you say, all right, we'll document what the situation is here and how many times this has happened and the facts, and we'll give this person one last chance. And they sign and you sign, and now you've got a pretty rock solid document that you've prepared that says, we've got you on all these things. And if you do one more thing that violates this, then that's it, you're out, and that's it, and that's all. And arbitrators tend to view those with favor because it shows that this person was really on their last chance. Kara, I don't know if you wanted to add anything there or not, but otherwise I'll discuss other settlement agreements.
Yeah, I would just, echo kind of what Mark said in that, yeah, those are really good opportunities to have a last chance, particularly if maybe this is an issue, you've got collective bargaining agreement coming up, negotiations coming up, and this might be something you can flood into those negotiations. And so rather than spend the time and effort and money in going to arbitration, you can resolve this, make it for last chance. And then if there's something to address during negotiations about the type of behavior, again, modifying the just cause language, those are things that would be good to implement rather than proceeding to arbitration.
Perfect. Thank you, Kara. If you do reach a settlement, it's a very good idea to put that in writing. Handshakes are great, but that's not much that you can rely on in later days, and people don't remember things often the same way. So it's good to put any kind of settlement in writing. Lay out what the employer and the union are agreeing to do, whether it's a payment or reducing discipline or what have you, when they're going to do it. Make sure from the employer side, and most grievances are brought by the union, and make sure you put in there that they're withdrawing the grievance and that this is a complete resolution and that you're not going to arbitration. It's often you always want to put in there a non-admissions clause that says by entering into an agreement, we're not admitting that we've violated the contract in any way or that we disciplined unjustly, anything like that. And often it's to your advantage and sometimes to all the parties' advantage to put in that we're settling this on sort of a non-precedent setting basis, so that we're going to do this, but nobody's going to point to this as precedent for any later situation. That's a good idea when you're resolving a tougher grievance, and usually with any kind of grievance, because you don't want to create a written past practice there in most cases. Let's look at, okay, so you haven't been able to settle, you've considered it or you don't want to, and now what's going to happen? Well, or maybe the union has just has filed for arbitration, and now here we are. How do you select the arbitrator? Well, for the Federal Mediation and Conciliation Services or for the AAA, these will usually be specified in the contract, like how the arbitrator is selected. So this is good advice for all of this presentation. Basically, is almost all this is contained in your contract. So as Kara said at the outset, if some of what you have in your contract it's not in there, or something that you don't like is in there, or you want to change something, flag that for your next negotiation so that you can put that in your contract. But most contracts call for the FMCS or AAA, or there's a panel that's specified in the contract. That will also determine how you select the arbitrator. If you get a panel from the FMCS, for example, they usually send you a panel of like 7 arbitrators that are in your general area and that they get from their lists and just send to you. Then you'll have to strike to get to the one arbitrator that will decide the case. Consider having something in your contract. This is from my standpoint anyway, because I often end up going through that strike process. I like to strike second because if the number is 7 and the union strikes first, that means my last strike will come when there's only 2 arbitrators left to choose from. And I think that that gives at least a little bit of advantage in choosing among the last two which one will serve as the arbitrator. So might be a good thing to consider having in your contract, is that the grievant will strike first, because that would ensure that you always strike second if that's what you wanted. There may be a contract panel that it's just the next in line, or it's a random assignment from a random generator, something like that. If that's how it is, that's how it is. But if you have the chance to learn a little bit about your arbitrator, take that chance. Look at the CVs or the resumes. Those come with the FMCS or AAA panels. Do a Google search. Check and see what their costs and cancellation fees are. Where did they work? Who did they represent when they were, many of the arbitrators are lawyers that were previously in private practice. They don't have to be lawyers, and some of them are not, but many of them were, and you can get a clue from their work history which side they might lean on. Most of them that have been around for a while, though, tend to be around for a while because they're generally viewed as middle of the road and not biased one way or the other. You can do some legal research in the legal databases, Westlaw or Lexis, or if you have access to anything like that. Some associations in your area might have contracts and arbitration decisions for the area. You can check there. And just doing a Google search, some arbitrators have opinions that are out there on the internet, or some of them have websites that might be helpful. Once the arbitrator is selected, you basically get with him or her to determine when the arbitration will be held. It depends on how busy the arbitrator is and when the parties can get together. Consider in that who might be on vacation, or is this person leaving the company? Is there a retirement coming up or something? Or your witness is going to be available. If it's in the summer, might they be on vacation? Things like that. It really does make a difference who your arbitrator is. I had an arbitration once that had two different employees, and the union fought, and I think good for them. They had the right under the contract to have separate arbitrations because both employees were on video doing something that they shouldn't have, and they got separate arbitrators, and we ended up with basically the same case, but one arbitrator ruled for us and said, there it is on video, and the other one discounted the video and said, well, you still, just cause implies a reasonable remedy too. And so like it said in the email for this pan or for this webinar, arbitrators are sometimes a box of chocolates, so it's best to try to find out what you can about the arbitrator. If you can get the right one, that carries a lot of that will get you past a lot of potential issues. Now, so you've selected the arbitrator and you have the arbitration looming out there in the distance. What do you do to start getting ready? Well, you got to prepare, and that's basically sort of revisiting a lot of the key facts and legal issues that you've developed through the grievance process and through the various steps. Really start evaluating witness credibility and supporting evidence, and determining who might make the best witness for particular issues. You don't want to spend 2 or 3 days in arbitration. You want to narrow this down and present a clear and coherent case for the arbitrator. Which witness is going to be best to get certain documents admitted? Do they have familiarity with the documents and the policies? Were they involved in this? Can they testify to the various things that you need to show? What is their availability, as I mentioned before? What about drop-off of prior write-ups and discipline? Have you considered that? Many contracts will say you can't consider discipline outside of certain range. That's a consideration here. Make sure that you have all the files of managers and supervisors. It often happens when I get involved in a case. I'll ask questions of the managers and say, I'll have like the HR file or something. But when I meet with the managers or the supervisors, I'll say, well, do you guys have anything? Oh, yeah, I have a little file that I kept at my desk. Oh, I was unaware of that. Could I have that, please? They may have personal notes. They may have emails that they sent to themselves. There may be something on their calendar about meetings that they held, or their personal phone often will have texts or calls things like that, you need to find out, because if HR was unaware of it and the actual file doesn't contain it, you need to make sure that you have everything. Ask for who else might have the information. And as Kara mentioned too, make sure you secure the digital evidence and video, especially now that you're headed for arbitration. Make sure that something is not going to be unintentionally deleted or overwritten, and that you won't have it when you need it, especially if it's good evidence like the photos or the videos or texts or calls. Don't wait. Move quickly to lock all that down. Get on site. If at least when I get involved, I like to get on site. And if you're not on the site where this happened, go out there and visit it and sit down with the people that were. Meet with the frontline folks and determine, do they have additional information. You might see something when you get on site, or go look at where all this happened or what happened, that you might see something that could be beneficial for the presentation of the case. If you do get counsel involved here, it's good to have them come and see what's going on and show them all this information, and maybe present all this information to them, because they can be a good outside resource as they weren't involved in all this. They didn't know, and what's their reaction to a lot of it. They may point out something that would be good for you to consider. How do you get information that's not in your possession? How do you get it from the other side? There is no formal discovery, and arbitration is kind of the wild, wild west in that respect. You can make a written request and possibly file an unfair labor practice charge, but depending on the timing, an unfair labor practice charge is not going to make too much of a difference with a pending arbitration, because it'll take the NLRB a long time to decide that case. It may be worth threatening and trying to get some information that way, but it's good to have a good working relationship with the other side, that hopefully they'll share some information with you. They'll be asking for the same thing from you. You might get the arbitrator to issue a subpoena, but most of those are more likely to be honored by coming to the hearing. So even if you get documents or the witness that you've subpoenaed, you might not get it till the hearing. So you have to consider that. And then finally on this slide, I really want to emphasize, secure the court reporter, an interpreter, or a location if it's not going to be at your plant, anything like that. Make sure you have a court reporter. Unless you explicitly don't have the right to a court reporter, it's good to have a transcript of what goes on at the hearing, and you want to lock that down early. So I would recommend, if you don't have in your CBA some sort of provision in the grievance and arbitration provision that says that the parties will split, arbitrator fees and court reporter fees and interpreter fees, or, any related fees, something like that, then at least you've gotten in there that you have a right to a court reporter. And that is important, as we'll discuss later on, for writing your brief, and for keeping the witnesses more honest, because they know that there's somebody there that's taken down everything that they say. Let's go on then. I guess, Carrie, you can talk about the arbitrability issues and go on from there.
Great, thanks, Mark. So when we're talking about arbitrability, we're really kind of covering two important legal issues. And I won't get too in the weeds on this, but I think that this is very important because it can strategically be advantaged for the company. So the first one is procedural arbitrability, and that really focuses on timeliness. Did the grievance timely comply with all of the steps of the process? You remember I said earlier today, really important to have step 1, step 2, present the written grievance within a certain number of days, schedule the grievance meeting within a certain number of days. The company provides its response to a certain number of days. And then if it doesn't resolve it there, the union has a certain number of days to present it to arbitration. If any of those timelines are not met by the union, in this case, if they're the ones that presented the grievance and want to pursue arbitration, and you've documented that in your response, and you've raised that issue throughout every stage of the process, when you get to arbitration, you can say, this is not arbitrable. Doesn't matter how strong you feel in your position, union, you have not complied with the terms and conditions of the CBA, and as a result, the arbitrator has no jurisdiction. I have argued that several times. I've been successful in some, I've been unsuccessful in cases where the employer didn't raise it earlier enough in the process and let kind of deadlines go freely on both sides of the angle. So I think it's important that knowing that if you don't comply with the timelines, that can constitute a waiver of arbitrability at the end. If it goes forward, you could always argue with the arbitrator, I have a procedural arbitrability issue that I want you to hear before we get to the merits of the dispute. Sometimes the arbitrator will bifurcate that. I had that situation come up a couple months ago in my arbitration. We argued the procedural timeliness issue first, and then second went to the merits issue, which was a contract interpretation issue, which the union had its burden of proof on. So I tried to separate it, even not going to a hearing on the merits, but the arbitrator wanted to hear it all at once. But still, it was advantageous because I got in front of the arbitrator very early on after she was selected that, hey, we have a procedural issue here on timeliness. And it laid the groundwork for what I think is a really important argument, and ultimately potentially a strategic success if you're holding the union accountable. Another type of procedural arbitrability issue is a continuing violation. A lot of times the grievance says the grievance must be filed within 10 days of occurrence. And oftentimes arbitrators will say something like a pay, every time you issue a pay and it has the wrong overtime or it has the wrong rate of pay or something like that, every schedule or every pay period is a new occurrence. And so kind of narrowing down when they knew about that occurrence, when they knew or should have known about that occurrence, it needs to be within 10 days of that, not just of the occurrence, in order to kind of fight back on the continuing violation theory. And then, as I mentioned, if the employer has a past practice of processing untimely grievances, the union can use that past practice to say, look, the employer isn't really holding anyone accountable to these timelines, and therefore they shouldn't hold them now. So that's something to be important. If you otherwise have unambiguous language on time limits, if your past practice could overcome that, that's something to be aware of. The second type of arbitrability that I want to cover is substantive, and this is less common that arises. It's really, is the nature of the dispute one that is proper for arbitration? Is it addressing a specific subject that's covered by the CBA? For example, is it a meal break issue, something that is right clear within the terms and conditions of the CBA? Or does it cover something that maybe you have the management right on relating to the operation of the business? Maybe it relates to some type of reducing parking lots, spaces in your employer provided parking lot, something that's really have not been addressed by the CBA. Is it something that the CBA specifically precludes arbitration over? As I mentioned, there may be some issues, maybe some side letters, some other deals that you're making with the union that says, look, this is not subject to the arbitration provision, something to review. Similarly, if the grievance is based on a violation of law, statutory law, it may be more appropriate that the union use the statutory process, like Title VII or the state law, versus the arbitration provision. But generally, that discussion, if you have that argument, you say, we need to defer that question to the courts. Very few employers use that issue. Oftentimes, an arbitrator will decide whether something is appropriately substantively arbitrable rather than a court of law. But it's just something to be considered. Oftentimes, if the grievance addresses a subject that may not be addressed by the CBA, but otherwise does affect their terms and conditions of employment, or if it's a long-standing practice of the employer, something that's been going on for a long time, that might blend it into a more appropriate arbitrability issue, and limit your abilities to raise that as a defense. But the point I wanted to make with these two slides are these are two things that you should have legal counsel review at the outset of deciding moving forward to arbitration, whether there might be some really good arguments before going into the merits of the case. And then other things to consider as you're preparing for arbitration. Again, are there any side letters that might be important that were not attached to the CBA? Are there any company policies, whether you've got your handbook or other policies, that might bear into play with respect to discipline or terms and conditions of employment, or even just sort of operational issues that are not set forth in the CBA, but might play into what the employee's understanding was of the expectations of their performance and discipline and code of conduct that might be relevant exhibits. Again, you want to look at the management rights provision. Does the dispute somehow implicate that and give you full undiscretioned management rights to implement whatever is the nature of the dispute? And you can rely on that as a defense. We like to look at, previous grievance settlements, how you've resolved other issues with the union before. That could implicate an interest or some knowledge about maybe where the union might be willing to resolve this pre-arbitration. Past practice is a whole another huge topic that is a little bit outside of today's conversation, but something being aware whether past practice, which is how the parties engaged in a course of conduct when the contract is ambiguous, does that implicate and maybe provide additional defenses and arguments that you may have as to why you acted in this way, and it's because you've always acted in this way over the course of several contract terms and had never been challenged or raised by the union in the past. And then the last two things is, let's look at both of what, how has the union addressed this issue in arbitration with other employers, or what do they consider it to be common in the industry? Those are issues I've had to deal with recently where, a union was trying to introduce evidence of how they obtained a successful arbitration on a similar issue with another employer. And I shut that questioning down pretty quickly because I'm like, I'm not a party to that collective bargaining agreement. And how another party does their business is totally irrelevant to the contractual dispute that we have with the union. And the arbitrator, was receptive to that argument and didn't really allow a lot of questioning about how other employers interpret their CBA. Doesn't have anything to do with contract interpretation of the contract with the single employer. And then, Mark covered a lot of these, so I won't spend too much time, but, the importance of preparing witnesses, both early on in the arbitration procedure, but also, on the day before, the 2 days before. I meet with witnesses the day before the arbitration, again, to make sure that they are the best witness we can put forward, that they're able to answer questions. I do a ad hoc kind of mock questioning, both from a direct exam, but also potential cross-examination. So you really want to understand and make them feel comfortable that they're ready to testify in what might be the first time they've ever testified in what is arguably an informal process, often in a conference room. But still, they need to be comfortable with the documents that's going to be introduced to them, what evidence they need to present and get in front of the arbitrator. They need to be comfortable with what the theme of your case is and how they participate in the theme within all the other witnesses who are testifying. So really important to make sure that you are meeting in person with witnesses throughout the process, but in particularly early, right before the hearing. And then Mark will talk about this too, the securing stipulations at the hearing. You can do that in advance, and that can certainly avoid testimony and might make some of your witnesses, a little smoother and faster and most efficient. And then finally, Mark covered this. There might be some documents or evidence that are not in your possession. So throughout this process, you want to think about whether you're issuing a request for information to the union, whether you're issuing an arbitrable subpoena. As Mark mentioned, they might not provide the documents or the witness until the hearing. So you want to have time to be able to review that information and how that might impact your overall case. As Mark mentioned, filing an unfair labor practice charge really is not practicable because of time, but is something if you feel the union is withholding evidence. And then always, thinking through how do you creatively and effectively and impactfully display your information to an arbitrator. Consider using charts or graphs if you've got difficult to digest information. Always pictures, videos are solid evidence. If you've got evidence and photographs of someone drinking on the job or sleeping on the job, and you've got video testimony of that, that's going to be very hard for the union to refute and for an arbitrator not to take seriously as a reason for a particular action. So with that, I'll let Mark close up with the hearing and post-arbitration briefing.
Great, thanks, Kara. Initially here, some of the preliminary issues. This one echoes a little bit of what Kara mentioned right at the beginning about the burden of proof. It depends on the type of contract. If it's a contract interpretation case, then the union will carry the burden of proof. And if it's a discipline or discharge case, then the employer usually has the burden of demonstrating just cause, again, subject to whatever caveats are specified in your collective bargaining agreement. The burden of production is a part of the burden of proof and usually goes with it, meaning that that person has the burden of going first. This can be at least a little bit of an advantage, or maybe you have a comfort level with the other side going first because you get to hear and see their case before yours. So in a contract interpretation case, most I'd say I don't know any arbitrators who would be different, do it differently, but the union will go first when it's a contract interpretation case. And that means the union has the burden of putting up its evidence first and its witnesses. So you get to see basically what you get to attack. In a discipline and discharge case, the employer has the burden to demonstrate just cause, so they have to go first, and your witnesses are up first. That is at least a little bit of a slight benefit to the grievant in that they get to hear sort of the case against them before they ever have to put on their case and testify. Another preliminary issue is whether to sequester witnesses. These preliminary issues, I should mention, are things to consider sort of that are generally things that the arbitrator will bring up at the outset of the hearing, and things that if you discuss with the other side ahead of time will go some distance in making things nice and smooth day of, or as smooth as possible day of the arbitration. Whether or not to sequester witnesses is one of those considerations. And sequestering witnesses basically means that everybody's out of the room and they only come in when they will testify. If you're not aware, the arbitration is just usually held in a conference room or something like that, with the arbitrator at one end, maybe the court reporter there, and then each party sits on each side, and the witness comes up and sits by the arbitrator and is sworn, and the case proceeds that way. If you sequester witnesses, which I probably recommend, I mean, it's all case specific, and sometimes in a contract case, it may be less significant than in a discipline case, or in a case where you have a pretty strong factual dispute. It's probably advisable to sequester because you don't want witnesses tailoring their testimony one to another, and you may be better off with each witness standing on their own knowledge. Even if witnesses are sequestered, the grievant has the right to stay in the room, and the union has the right to have one person in the room to assist the advocate. Now, the advocate here is the attorney, so there could be as many as 3 people on that side, usually like the business agent or something. And the company has the right to have the company representative, even if he or she is a witness, can stay in the room to assist with the advocate. And the thinking behind that is that there needs to be somebody there who knows, the company and what happened and what this is all about. The attorney, like, things may come up that the attorney may not have any knowledge of because it's something that's just within the knowledge of the company representative. You might also discuss other arrangements that might be made as to witnesses. Like, for example, if somebody is no longer with the company and you've agreed that they don't have to travel from, wherever they have moved or something to be a witness. Maybe you've agreed with opposing counsel that they could appear via phone or by Zoom or something like that. You could make that known to the arbitrator. Arbitrators will generally accede to the agreements of the parties in this respect. And if you agree to take somebody out of order, this guy has a work schedule, so he can't be here until the afternoon. So we're going to take him out of order in the afternoon. Or this guy has to be to work at noon. And I know it's, the union's burden, but this guy needs to testify so that he can get to work. You can agree to things like that too. And then the stipulations, Kara also mentioned, but this is something to really think about before the hearing. When you get with the other side and agree to certain stipulations, like the issues to be decided, joint exhibits, what's sort of the background stuff that there's not going to be any dispute about from either side. I like to try to get the other side to agree to some basic facts, just so that that's easier for the arbitrator to understand the case. Remember, the arbitrator is coming into this blind. They don't know anything about the case or your workplace or what happened. And sometimes witnesses are, nervous or whatever, or sometimes certain things that seem obvious to everybody else are not brought up. And so the arbitrator is left scratching his or her head thinking, well, what I don't know some of the basic facts here. If you can put something down in a stipulation as to the background and the basic facts, I like that. And it also shows that the parties are working together. I think it's a benefit when it shows that you've made good faith efforts to cooperate, makes it easier for the arbitrator, and can see that you've tried to make this as easy for the arbitrator to decide as possible. And hopefully, if there's some facts that are undisputed, you can get them into the record and then rely on those. Remember, like you that will be an exhibit, and you can use that in your post-hearing briefing. I also like, one final thought as to the joint exhibits, is to try to get any exhibits that you're going to rely on as the employer. If the union agrees to make those a joint exhibit because it's not disputed at all, that's even better, because it just comes across as like, when you're relying on the evidence that they've already agreed as a joint exhibit of theirs, it's in some sense sort of adopted that, and that's a good thing to be able to point to as a joint exhibit. You also should give at least some forethought to the statement of the issue. The arbitrator, right at the outset of the hearing, is going to say, what's the issue? And there are some formulaic statements out there as to, especially in discipline and discharge cases, they'll say, the typical just cause would be, was the grievant disciplined or discharged for just cause? And if not, what's the remedy? They'll have some sort of statement like that. You need to consider what the statement of the issue would be from your standpoint in a contract interpretation too. That's for anything. The arbitrator is going to ask that. You don't have to agree. Each side could have their own. And then if they don't agree, the arbitrator will just say that they will decide it as part of deciding the case. And then an opening statement. The arbitrator will ask for opening statements. One little something that's different from typical litigation is that you get to decide when to make the opening statement if you don't have the burden of proof. So if the union has the burden of proof in a contract interpretation case, they'll make the opening statement. The company could defer to their case in chief, but I usually give mine up front. But I have seen the union defer its opening statement in a discharge case until after the employer has given their opening statement and then presented their case in chief, and then the union gives their statement. Again, they do that sometimes to try to see what the employer is going to say and what evidence they're going to present. Prepare the exhibits. It's always helpful to not be scrambling around at the hearing trying to have different copies. You should bring at least like 4, maybe even 5 copies of every exhibit. Pre-marked, the joint ones and the ones that are stipulated. And if they're not pre-marked, have stickers and a pen that you can write on there what exhibits they are, and make sure to move those into evidence as you present them to the witnesses, and ask the arbitrator to accept them into evidence. That's all. Again, that's why it's helpful to have some stipulated exhibits. All that can be done in advance, and make sure to bring those additional copies, because you'll need one for the witness, one for your side, one for opposing counsel, one for the arbitrator. and maybe one to turn into the court reporter. So have plenty of copies of each exhibit that you intend to rely on. Let's look just briefly at presenting the witnesses and evidence. Like I said, the party with the burden of proof will present its case in chief. Each of the witnesses will then be subject to cross-examination. From the employer side, I like to, hopefully the other side has shared who the witnesses are going to be, but they may not have. I mean, like I said, it's a little bit of wild, wild west, and there might be some surprise witness. You just need to be prepared for that. But if you've done all your homework and researched everything and gone through the investigatory process, you probably have a pretty good feel for who they might bring. Another way to find out is if it's somebody from work, they often have asked off from work to be there, and you know that means they're probably going to show up. You can prepare in advance for what the cross-examine will be, and I think you should have some outlines of like what you anticipate the issues to be. Remember, the evidence rules and hearsay objections will all be pretty relaxed to non-existent. Most arbitrators don't apply strictly those rules, and they'll allow most things in that have any sort of relevance or basis to them. And even some things that don't, many arbitrators will just say, well, I'll let it in for what it's worth, or that goes to the weight of the evidence. I'll take a look at it. And you can tell from sort of how they're saying it, what they really think of it. But most, it's not strict rules of evidence and hearsay. So that's something to keep in mind. At the end, you'll, after both sides have put on their cases in chief and rested, if there's something that was come up that was unanticipated and that wasn't addressed, you have the opportunity to put on rebuttal evidence in your rebuttal case. And then there will either be closing arguments or briefs. I say closing arguments or briefs. Sometimes it could be both, but in most instances, arbitrations will not end with a closing argument. They'll end with written briefs that are submitted to the arbitrator after the fact. So you might want to give a closing argument, and maybe the arbitrator would let you. And sometimes that's the case under certain contracts where the contract will not allow for post-hearing briefs, and it'll say you have to make a closing argument. In that case, you just need to be ready and sort of have your thoughts formulated and then tailor that to what happens at the hearing and give your closing argument. But let's talk for a minute about post-hearing briefs. Those are most often due within 30 days after you get the transcript from the hearing from the court reporter. The arbitrators, almost everyone that I've ever dealt with, will just be like, look, that's typical 30 days. If the parties agree for one reason for another that, we need another 30 days or we need a week or whatever, the arbitrator will just say, just agree amongst yourselves and then send me a note. And most of them will allow you to agree to different deadlines. As far as writing the brief, organize it well. Generally start with like a summary of the facts and get your facts in a row. And this is why it's helpful to have the transcript. You can point to the sworn testimony of the witnesses and use the key documents that you had admitted, that quote from those or cite the exact language. And you can cite to the transcript page and line where the testimony occurred. Stress the burden of proof in the case. It's particularly in the contract interpretation. If it's a close issue, it's worth mentioning to the arbitrator and reminding the arbitrator that a 50-50 issue on a contract interpretation should go the employer's way because the union has the burden of proof. And keep it a reasonable length. Make your points. You want to be respectful. You don't want to go on and on and on. You want to be concise as possible. Certainly be respectful of the whole labor relations process and respectful of the other side. You generally don't want to write things like, oh, this person was caught in a lie, or, unless it's black and white, clear as day, you're far better off letting the arbitrator draw his or her own conclusions, and you look like a reasonable person that's just setting out the facts for them to evaluate and draw their conclusions. There is no reply brief in most every instance. There's no reply brief. You can ask, I guess, but it's not typical in arbitration, and it would be up to the arbitrator to allow a reply brief. I'll close here with like other post-hearing issues. Let's say things really went poorly and witness self-destructed, or it turned out that things were not the way that you thought. Um, for one reason or another, your case did not go as well as you think. You can still always try to settle it. I mean, approaching after a hearing would may not look great, but it may be better than straight up losing, or maybe there's a reason you don't want the opinion to come out, and it might be better to try to settle, um, even on a basis where you have to pay and or do something that maybe you didn't want to. That's something to consider. Certainly incorporate any issues into the next collective bargaining agreement. This goes for positives and negatives, that you look to, you're always looking towards the next agreement. And I urge all the employers to keep a negotiations file, and the manager should keep any grievances that are raised, or arbitrations, or issues that come to their knowledge. Put those in a file and keep them for when your next collective bargaining agreement negotiation session is coming up. And certainly if something doesn't go the way you want at arbitration, you may need to change the language and deal with that. Whether you win or lose, make sure that you implement it, though. You need to let the supervisors and managers know. You need to, maybe if it's a vacation issue or scheduling or overtime, something that others need to be apprised of, like payroll or the administration or HR, ensure that they know so that they can implement, particularly if you win. I mean, if you win on a case where you have the right to do something, make sure that everybody knows and that they're not doing it the wrong way. Whoever is going to implement your CBA needs to be aware of what has happened. And finally, I'll close on like the challenging an arbitration, whether you win or lose, is very challenging, to put it lightly. There's an old Supreme Court case that held that it's when the parties have committed something to arbitration, it's generally going to be binding. And the standard that the Supreme Court laid out was, did the decision draw its essence from the collective bargaining agreement? That sounds sort of flowery and squishy, and I guess it is, because it's very broad. The only way that you can get an arbitration overturned is where you can legitimately say that the arbitrator, as the Supreme Court puts it, dispensed his or her own brand of industrial justice. If you can show that they violated an express provision of the collective bargaining agreement, then you have a chance. But as far as like deciding the facts and largely the law, the courts will defer to the arbitration, because they presume that's what the parties intended when they agreed to arbitration. So I think the statistics are pretty stark about almost every collective bargaining agreement has an arbitration provision. And in most instances where something goes to arbitration, that result is going to stick. I think about 1.5% of the cases ever get challenged in the courts, and most of those fail because the arbitral standard is such a high one. That's all I've got on post-hearing issues.
Okay, thank you, Mark. Appreciate everyone's attendance today. We'll wrap it up. These are some upcoming webinar series for the rest of the year. But for those of you that do have collective bargaining agreements, we are having a masterclass in September on how to effectively bargain coming up, and things that Mark and I talked about as we'll deep dive a little bit more. So please be sure to register for this if this is something that's of interest to you. And then we've got a lot of other programs and blogs and services and an upcoming California Summit. But please make sure that you are staying apprised of what we are offering. And if we can provide you with any additional comments or questions following today, I know we didn't get a chance to get into the chat, but once we do, Mark and I will respond to any questions that were posted there after today. In the meantime, thanks everybody for your time, and hope you found what Mark and I shared to be helpful, and don't hesitate to reach out with any further questions.